I welcome you all to the second phase of the International PhD in Progress weekly seminar series organized by the Global South Network. The first phase of this series started in May 2023 and ended on 23rd of August. Student and staff from 8 disciplines, 22 universities and 8 countries participated in the first phase. The second phase started last week and is going to end in December 2023. Thanks to the organizers of this weekly seminar series, including me, Dr. Noman Rayat, lecturer in law at Lister Law School, and the convener of the Global South Network. And please allow me to introduce today's panel. I'm Dr. Noman Rayat, lecturer in law. I'm the convener of the Global South Network at the Lister Law School, University of Leicester. My research interests lie in the broad area of constitutional law and politics in authoritarian and hybrid regimes. I will be, I'm joined by Dr. Jocelyn, lecturer in law, School of Law, University of Leicester, who is a discussant. Dr. Jocelyn researches in the field of public international law and joined the Leicester Law School in 2022. Jocelyn has previously held academic positions as a senior lecturer at the University of Nigeria and associate lecturer at the University of West England. Jocelyn is also a qualified barrister and solicitor of the Supreme Court of Nigeria. I'm also joined by Eva Carolina Garbaz. Sorry for my incorrect pronunciation if it was. She is a doctoral researcher and graduate teaching assistant at the School of Law, University of Leicester. Today's speaker is Sonia Anaid Davila Cruz. She completed her doctoral degree in law research at the Dixon Boone School of Law, King's College in London, and passed her viva with minor corrections on Wednesday, 13th of September. Congratulations, Sonia. Today, she is going to present her project titled The Abuse of Power by the Executive at the Intersection Between Constitutional, Democratic, and Legal Theory. Just to be clear, when we contacted Sonia, she was in the final phase, was about to submit her dissertation, and that's why she was her PhD was in progress. And so by now, on 13th she completed. So probably, I mean, people might be thinking that why it's in PhD in progress series. So I thought I should clarify. So Sonia, you have 25 minutes for the presentation, which will be followed by 15 minutes for comments, questions of discussant and peer commentators, and 15 minutes of question and answer session by attendees. So the floor is now yours. And once again, congratulations.
Oh, thank you. I have some slides. I think
Yes,
I can.
please go ahead. If you struggle to upload that, please let me know so that I can upload the slides.
Yeah.
Or if you want me to, change the slides just to avoid distraction, please also let me know.
Okay. Okay. Me. Yeah. Can you see the slide?
Yes, we can see.
Okay. Okay. So the original title of the presentation, I think, was rather the broad topic. So I work mainly on constitutional law, democratic theory, but my background is philosophy, and I'm also interested in more generally in legal, moral, and political philosophy. So I think you might see why I would think this project is a project on jurisprudence mostly. So this is the actual title of the presentation, and this is the first chapter of my thesis, which is called unilateral executive power. What is it and what is wrong with it? And yeah, I look forward to hearing your comments. So this is the presentation plan. I will start by defining what unilateral executive power is. Then, I will try to explain very briefly how or why exactly this exercise of power is possible. I will then distinguish between two forms of unilateral power, and then I will compare three different conceptions of the rule of law. I will then determine which of those conceptions are or may be compatible with unilateral power, and finally I will just briefly conclude by mentioning some reasons why unilateral power may be wrong. Okay, so this is my definition of unilateral executive power. So I'm thinking of a form of arbitrary power, and as we will see, the fact that it's arbitrary is very important. That is exercised by government. So I'm not thinking about the executive branch as a whole, but only about its head. And this, even in those cases, which are the majority of cases, in which the head of government has assistance from its cabinet or a group of ministers. So that's one part of the definition, and the other part is that it's not duly constrained by the Constitution or the law or any other agency of government. And this, of course, is going to be also important to clarify what I mean by duly constrained. Yeah, so how is this form of power possible? There are three different maybe groups of literature that directly or indirectly address this issue. The first is the classic issue about the indeterminacy of the law. So this started maybe already with Hart in 1971, when he wrote this chapter on his book, the concept of the law, on the open texture of the law, and he just gives many examples of why law is indeterminate and why it's necessary that law is indeterminate. So the indeterminacy of the law allows, in this particular case, the head of government to make single-handed decisions without being subject to the normal procedures to which decisions should be made. Or we could also think in democratic terms. If we're thinking about a constitutional democracy, we would think about the head of government not being properly constrained by the liberty procedures to which democratic decisions should be made. And then we have the literature on crisis and emergencies. These arose mostly after, well, already with John Locke, of course, but it has like this resurgence after 9/11, and so many authors started to worry about the excessive amount of power that the executive has in cases of a crisis and emergencies. And so David Dysenhouse came up with, or kind of retrieved this concept of a legal black hole and introduced the concept of a legal gray hole, which simply put refer to circumstances in which there is no law regulating the exercise of power by the head of government, or the law that exists is insufficient really to prevent such exercise from being arbitrary in the sense of violating human rights in the most extreme case. But we can also think about excessive discretion, for example. And then we have the literature on fuzziness. This is kind of relatively new. This is a concept introduced by Margit Kohn in 2021 in her book, A Theory of the Executive Branch, Tension and Legality. And well, she kind of probably what makes her different from previous analysis of this topic is that she offers a taxonomy of what she calls 13 forms of fuzziness. And among them, although not necessarily with this name, we could mention, for example, well, excessive or like the massive delegated legislation on the executive. We could think of excessive discretion. We can think of the royal prerogative in the UK. We can also think about executive decree authority in other countries, maybe especially presidential systems, and also the executive veto. So these are maybe some of the cases in which we could think that unilateral power could be possible. Okay, so in relation to legal holes and the issue of crisis and emergencies, this is something that I introduced in this chapter of my thesis. And it's a table that aims to kind of summarize the different responses that have been given to a challenge that was posed by Carl Schmitt, who said that any response to a crisis must be exempted from the requirements of the rule of law. Of course, here we would need to clarify what we mean by the rule of law. But this is just a classification in that sense of the position that different authors have taken in relation to this challenge. So on the left-hand side of your screen, you have Carl Schmitt and also contemporary authors such as Eric Posner and Adrian Vermeulen, who suggest that, well, the executive cannot be constrained by the law at all in cases of emergencies. And as such, the authority that it has is not really constituted by the law. John Locke takes a more nuanced approach in a sense. He says that, well, a state of emergency, yes, it's located outside of the constitutional order, but it doesn't mean that the executive always acts without being constrained by the law. Bruce Ackerman thinks differently, more in the direction of legality. He thinks that the power to declare a state of emergency may be found in the Constitution. But all these for David Dysenhouse is insufficient. So the responses that these three groups of authors give are insufficient because he thinks that even in the cases of crisis or emergencies, the executive should be constrained by the requirements not only of a kind of formal or thin conception of the rule of law, but rather the requirements of a substantive conception of the rule of law. And he thinks that this substantive conception of the rule of law includes the idea of complying with substantive values such as basic human rights and civil liberty. So he thinks the executive should be constrained by this conception of the rule of law in all cases, even in the cases of emergencies. As I do try to suggest in my paper, I would suggest that David Eisenhow's position is too extreme for various reasons, mostly because the substantive conception of the rule of law is very demanding. And so I would think that a better approach to this particular problem would be to consider instead a procedural conception of the rule of law. So the authority of the state or of the executive is constituted by the law, but not necessarily by the law of a substantive conception of the rule of law, but rather the law of a procedural conception of the rule of law. And a procedural conception of the rule of law refers simply, or well, in simple terms, to the requirements of due process, for example, and judicial review. So even in cases of crisis and emergencies, the executive should follow a certain due process, and it should have, there should be some form of judicial review as well. So this is kind of my approach to this particular problem. In the case of fuzziness, which is the third group of literature, this is just another table not made by me. This is in Margit Kahn's book of her 13 forms of fuzziness, just for you to maybe to put it a bit in context. Right, so now thinking about the two different ways in which we can understand unilateral power, is important to go back and think what exactly the concept of arbitrariness means, precisely because we have defined unilateral power as a form of arbitrary power. So I've kind of struggled with how to call these two senses of arbitrariness, but for the purposes of these presentations, I've called them cruel arbitrariness and benevolent arbitrariness. So when a head of government has this unilateral power, she may exercise her power arbitrarily in two different senses. So on the one hand, she may exercise her power in ways that are despotic, oppressive, or that really only favor her own personal interests. So this is what I would call cruel arbitrariness. But of course, she may also be a benevolent person, and she may decide instead to exercise her power in ways that, even though they're not oppressive or tyrannical, they're based on her particular understanding of what the common good is, or what would be advantageous for a particular political community. So these are the two different ways in which someone may exercise unilateral power, or a head of government. This would lead us to conclude that the exercise of unilateral power is arbitrary, not only in the sense that the head of government may make cruel or self-serving decisions, but also in the sense that she may make decisions that are discretionary, completely discretionary, or that depend solely on her own good will. Now, what I'm looking to do now, in a kind of revised version of this first chapter of my dissertation, is to focus on the relation between these two concepts, which would be arbitrariness on the one hand and domination on the other hand in this Republican sense, or the civic Republican sense advocated mostly by Philippe Petit. And what I want to argue is that Philippe Petit has wrongly, at least in his first first versions of this Republican conception of political freedom, he has mistakenly identified arbitrariness with domination. And this really leads to various problems that I want to avoid. And so my proposal would be to say that arbitrariness is actually not as demanding and it's not as broad as domination is, which means that there may be domination, for example, even when we don't have arbitrary power. In other words, we can have domination in a deliberative democracy, for example. Even when decisions are made deliberatively, we can reach decisions that are not completely fair or that in one way or another dominate at least one group in society. So domination in that sense is broader than arbitrariness. Not all cases of domination will be arbitrary, but all cases of arbitrariness will be cases of domination. This is kind of the distinction that I want to make. Relatedly, another identification that I think is incorrect and that Petit does in his first versions of this Republican conception of political freedom. He says, well, arbitrary power is that power that is not constrained to track the perceived interest of citizens. That's why he identifies arbitrariness with domination in the sense of not tracking the perceived interests of citizens. I would say that this identification is too demanding, and we should instead conceive arbitrary power as that power that is not duly constrained. But of course, now I have the issue, kind of the problem of trying to explain what duly actually means, which is not something that I'm going to talk about right now. So a little bit quickly. So this is what is not in red was the first kind of diagram that I tried to draw to kind of explain the difference between unilateral power and oppressive power more generally. But there are some mistakes with that first diagram. So what I added in red is just to explain how I would see the diagram nowadays, which is simply the idea that the concepts of arbitrariness and domination should, in my view, be disentangled. So arbitrary and domination are not the same thing. Okay, so these lead us to three different conceptions of the rule of law. I have already said a little bit what the procedural conception and the substantive conceptions are. The formal conception is the conception of law and Fuller. So it's simply the idea that the rule of law is associated with this with a list of attributes that any healthy legal system should have, which is really refer mostly to the form of the law or the form that a legal system should have. And that may include, for example, the fact that the law should be general or should be public, should be prospective or should be clear, should be consistent, practicable, stable, and congruent. Now, so which conception of the rule of law is compatible with legal holds, which we saw in the first part of the presentation? I already kind of mentioned this. So my proposal would be to argue that Eisenhower's substantive conception of the rule of law is too demanding. And also that actually legal wholes are compatible with at least some version of this substantive conception. Why? Well, because during a crisis, a head of government may actually act in accordance with at least some fundamental human rights and civil liberties, even if she is not constrained by the law or she's not duly constrained by the law. On the other hand, legal wholes are not compatible with the procedural conception of the rule of law, which is my preferred version of the rule of law, because during a crisis, a head of government may not comply with the requirements of due process or be subject to judicial review, precisely because she is not constrained by the law. This leads us to a related question. So which conception of the rule of law is compatible with unilateral power? In this first chapter of my thesis, I say that unilateral power is compatible with the formal conception of the rule of law because a head of government may exercise her power unilaterally, while at the same time making sure that laws has like these 8 principles of the inner morality of law, as Lon Fuller calls them. Of course, it's not very likely that a head of government exercising her power unilaterally will make sure that laws are general, public, prospective, clear, and so on. But it is possible. So it's not that unilateral power is incompatible with this formal conception of the rule of law. The same applies with or to the case of the substantive conception because of the reason previously mentioned. So a head of government may exercise her power unilaterally while at the same time acting in accordance with at least some fundamental human rights and civil liberties. Unilateral power, however, is not compatible with the procedural conception because a head of government may not exercise her power unilaterally while at the same time complying with the requirements of due process or being subject to judicial review. Yeah, so these kinds of this leads me to think about the reasons why it's wrong to exercise power unilaterally, or what is wrong with the fact that unilateral power is incompatible with this procedural conception of the rule of law. So some responses that we could think is, well, as already pointed out, unilateral power is a form of domination. But of course, we need to bear in mind that arbitrariness and domination are not identical. We could also say, like Raz does, that unilateral power, well, he doesn't refer to unilateral power, but we could use his argument of saying that it disrespects human dignity by creating uncertainty and disappointed expectations. And in relation to this procedural conception of the rule of law, we could say that the problem is that even if it doesn't actively interfere in the affairs of people or effectively threatens their human rights, it undermines the procedures through which power should be exercised, which for example.
Sorry for the interruption. You have 3 minutes, okay?
Okay, yeah, I have just enough time. Yeah, so it undermines principles such as deliberative democracy and this procedural conception of the rule of law, which we could also relate to the idea that it's a form of domination. We could also say that exercising power unilaterally, even if in a benevolent way, in a way that aims to promote the common good, for example, is wrong because it treats people in a condescending way. So it doesn't really grants them the autonomy to make decisions that they should have. And finally, another aspect that I want to explore is that the possibility of this unilateral power encourages certain political phenomena such as demagogy, paternalism, and populism. it's almost a completely different topic, but I think there are connections between the two, and I think that's it on yeah, on my presentation. So I really look forward to your questions. Yeah, thank you.
Thank you very much, Sonia, for such an insightful presentation. Now I invite Dr. Joycelyn for her comments. Dr. Joycelyn, over to you.
Hello, everyone. Can you hear me?
Yes.
Okay.
Yes, we can hear.
Yeah, thank you. That's a very good presentation, I would say. And to me, the important thing is that I think it's very contemporary, and in the sense that it's very, very crucial at the moment. You know, when you look at the conflicts, you know, in different parts of the world, talking about emergencies and all that. So you find out that leaders, say head of states, presidents, or prime ministers, or whoever is in charge, you know, is forced to take certain decisions. And at this particular point in time of decision taking, to what extent, you know, would you allow, you know, such person or leader, what level of power or what kind of law would guide decision making within this period? So I think that's the aspect I really find very interesting. So you find that it's quite, you know, important at this point in time. And I would also say you seem to have touched, you know, a lot of things, and your table, you know, I think I observed, you know, there was also, you know, good comment on that. The table you provided, you know, during your introductory part, and, you know, other diagrams you provided, you know, were also helpful in helping us understand the topic or the theme of your work. I think there seem to have been a lot of issues, you know, you try to raise. At a point, it's like I had a basket with so many things to consider what to eat. Am I going to eat domination? Am I going to look at, you know, what goodwill is, what's duly constrained, you know, and all that. So all that, you know, raises the complexity that will make, you know, a very good research. And I would want to, at this point, you know, say congratulations, you know, to you, you know, for successful, you know, defense of your work. I know I've just got about 5 minutes. So now looking at it, it seems there is issue, you do have issue with arbitrariness, and you try to look at different types of arbitrariness, and again the issue of duly constrained. I don't know if you might want us to have, you know, more idea of what you mean by duly constrained, because that would really you know, could either raise criticism or followership in your work. And what are you also trying to say, you know, about being duly constrained in times like we have today, in with all the crises we are looking at? Are there things, some factors that you think that can affect arbitrariness, or that can affect the discretion that head of states, or, you know, leaders in different jurisdictions, you know, could affect such? Say, are there some socio-economic issues, legal issues, some political issues, or maybe there are diverse regions that could actually, you know, influence this? Because when you are talking about it, it looks more like you are looking at a particular region or a particular state, you know, discussing that. But while others might appreciate that, others might want to understand, because if you talk about arbitrariness, and you talk about discretion, and you talk about goodwill, what is goodwill might differ from, you know, place to place. So are there, you know, issues? And are you giving us a summary or a total stand that there must be, or let's say, taking off arbitrariness or discretion on the part of the head of state. And if you do that, are you saying there is no kind of benefits if we do have some form of or a level of retainership of arbitrariness? Are you saying that will not be of any form of benefit? Are you saying we should take that out entirely? So your duly constrained aspects, what are the advantages and what are the possible limitations that could be faced? And if you do have some kind of suggestions to such constraints, I think that will be fine, to hear you. Thank you very much. I hope I didn't exceed my time. Thank you.
Thank you, Jasleen. No, you are completely within time.
Right.
Thank you for the comments. Sonia, would you like to respond to the comments now, or should we just, should we go to Eva, collect more comments and question, and then you would like to respond to all of those together?
Yeah, maybe I can respond now.
Okay, go ahead.
Yeah, thank you so much for your comments. I think, yeah, they pretty much addressed many of my own concerns. So, yeah, so I think, of course, it might seem from the presentation that the aspect that is more connected with like the contemporary state of affairs is missing, but and you also asked about whether I'm planning or I'm focusing on a particular region. This is probably something that I want to do moving forward. I would like to kind of draw more on kind of real life examples of this kind of unilateral power, not necessarily not necessarily give examples of unilateral power, but rather of the consequences that it may have in a more political sense. So I am very interested on populism, for example, and I think that they're maybe not so evident at first sight, connections between the idea of a unilateral power and the idea of a populist leader. But I think, it would be an interesting project, maybe try to find those connections between this more legal aspect of how this power may be possible or maybe enabled by the law itself, and the more political or practical aspect of how this translates into the behavior of our politicians. Then, of course, I'm also, however, very interested also in the conceptual aspect of trying to come up with a useful definition of arbitrariness. This is something that has been done already. The most maybe useful approach that I have found is that by Timothy Endicott. So he distinguishes not between these two types of arbitrariness that I distinguished. He gives 4 different accounts, and he takes one as the one that would be able to show in what sense arbitrariness is incompatible with the rule of law. So I also try to answer that question in my presentation. So I would say, as you asked as well, that no, there is no benefit to arbitrary power, because I consider that arbitrary power is a form of abuse of power. But this does not mean that there is not benefit to discretion, for example. So I wouldn't say that all forms of discretion are arbitrary. And that's why it's so important to have a clear understanding of what arbitrariness is. And the same goes with the idea of duly constrained, which would come, I think, from that definition of arbitrariness. So duly constrained would be all that is not arbitrary. So in Endicott's idea, arbitrary is the exercise of power that doesn't conform to what he calls the reason of the law. Now, of course, that's also very abstract, and it would be a matter of trying to come up with a more precise explanation of what this reason of the law is, to be able to then understand what would be duly constrained, what would be to conform to the reason of the law. But what is important, I think, is to say that this reason of the law is not the same as saying that the law has to conform to a particular understanding of the common good. This is also something that you asked, because then we would have the problem that Petit has, which is to identify arbitrariness with domination and to say that if we have deliberative democracy, if we track the interest of the people, then we don't have arbitrariness and we don't have domination. But I do think that we can have domination even in deliberative democracies. So that's why it's important for me to kind of distinguish between those two concepts. I think maybe that's it.
Thank you, Sonia.
Thank you so much.
What we could do is to first go to Yusuf, Eva, if you don't mind. So it's possible Yusuf might be asking some question which is quite similar to your comment. So let's go to Yusuf. If he, let's listen to his question, and then we'll come to you, and then you can respond to the question and comments together. Yusuf, over to you.
Okay, thank you, Norman. And thank you, Sonia, for the beautiful presentation, and congratulations on successfully defending your main, becoming a doctor. I wish you all the best that might come with. So yeah, I just have a comment or a question. So you have this very interesting table, and then you separated scholars' approach to different scholars' approaches to I'm struggling with the use of your terminologies and all. So yeah, but how different scholars approach the use of sole executive power or something, or arbitrariness. So, but you kind of distanced yourself from David Eisenhower's approach because you think it is quite extreme for still expecting that in terms of you call it black or gray hole, or maybe if we say fuzziness or emergencies, that the power, the person using the holder of a power or authority should still abide by some I mean, should still be constrained by the law and some regulations. And you try to distance yourself, and I was wondering why you want to do that. Because you know, if my own understanding is, and from David's, what I understand from David's approach is that if you leave this thing open, there are different kind of people. You might say someone will be benevolent and someone would not be. And then if you open it up and then you have someone benevolent, the person would not need to be constrained actually. But what if the other side happens, and then you know, people's rights are also in question, people's rights and liberties are in question, and you want to jettison that just to have someone's smooth use of power. So I was wondering, just wanted to raise a comment on that and to see what you actually your reasons for that. So thank you very much. That's the much I have to comment on. And thank you for the opportunity.
Thank you, Yusuf, for such a fantastic question. I think we're quite connected question is there in the chat box by Dr. Sigmund from School of Business. I welcome him. And so he's basically asking us about the importance. So in short, if I frame the question, it is about the importance of the research for a non-expert, for a non-law expert. So what's the use of this arbitrariness and the limits on this power to the general public? And having this said, just think about it. Having this said, let's go to Eva. Eva's comments. Eva comments might be helpful in answering the questions as well as the complementing the question. Go ahead. Over to you, Eva.
Well, thank you. No pressure, no one. I'll try to help. I'd like to just start by congratulating you, Sonia, and thanking you for this presentation. I found it really informative, especially with the comparison and visualization of all the theory and how it developed. It was as clear as it could be. I suppose with jurisprudence, it can never be super clear. And I'd like to also thank you for challenging some of those old concepts. I think we all know that legal theory and jurisprudence is riddled with old theories, concepts such as, I don't know, social contract, or the law as the reflection of society, which we all know what the flaws in there are, and I think it's great that you're addressing a few of those. And so my questions or queries really. I know you said that in the future you'd like to perhaps use the research you've done so far to maybe address some current issues. So my question would be, would you perhaps try and do a comparative study to use some of your theories, or adopting maybe a more socio-legal angle, and putting those to the test? I suppose you can still find many forms of the concepts of arbitrariness you've been describing in different countries and in different systems. So perhaps you could test them, how they actually work in real life. And the second thing is that I really find the crossover with populism super interesting. And as you said, populist leader does not equal sort of unilateral powers, but populism tends to flourish in certain circumstances. So perhaps you could look for answers in your theoretical research of where does it flourish, and can we pinpoint? Well, I'm working on Poland, so I can pinpoint a couple of places of where the rule of law perhaps is weak, or where those gaps are, so that the populism can actually develop. So yeah, that's me. Thank you.
Thank you, Eva. Just before I, ask Sonia to respond to your questions and to Yusuf's comments and Sigmund's questions, I just want to make an announcement that the recording of this session I plan to upload it to the Global South Network website. If you have any objections, because some faces or any names have also been recorded, so if you have any objections, please type in the chat box, or you can later also send me an email as well. Okay, thank you very much. So Sonia, over to you. Please feel free to respond.
Well, thank you, the three of you for your questions. I think, yeah, they're connected, and there's a lot of food for thought. And and thank you also for the congratulations. So I probably start with Yusuf then. So your question was related to the table and this classification of the different responses to Carl Schmitt's challenge. And I think the gist of your question was that so I reject Dyson-House solution by saying that it's too demanding or too extreme. And I think you were wondering why that is. Why I would reject his endorsement of the substantive conception of the rule of law. So yeah, I think my main concern is not with crisis and emergencies, but it was through that avenue that I came to thinking about unilateral powers. So I think I don't have like a really fully defined answer to the question of whether a substantive conception should apply in cases of emergencies or whether a procedural conception should apply. In my very personal view, I think that maybe not even a procedural conception could apply in cases of emergencies, and this is simply because because of the urgency of the emergency. We saw it with COVID, but we also saw how precisely that leeway that the executive had to make decision may become then an abuse of power, an exercise of unilateral power, if we want. So my main concern is not with emergencies. I wouldn't even be able to say that the procedural conception should apply in cases of emergencies, but I do think that it's a very clear case of why this may be problematic. I just simply think, if that responds to your question, that wanting for the executive to comply with the substantive conception is unrealistic. But in the same way, I think it might be realistic to want an executive to comply with the procedural conception in cases of emergency. So that's why it's also not fully answered for me, this particular problem. Maybe that leads me to the second question: why do we need to learn about executive power and arbitrariness and power in general? And it's also kind of connected with Eva's question. So because of my background, which is very much in the theoretical aspects of law and philosophy, it might not seem that I do have like a real life motivation for this research. So I'm not thinking about the particular region I'm concerned with is Latin America. So I unfortunately don't have much knowledge or any expertise at all in Eastern Europe, for example, or other countries around the world where we might have seen like this emergence of populism recently. Also, even maybe in Western countries. But it is something that has been very much in the history of Latin American countries, and of course this has causes that are not legal at all. And yeah, one might say that it's something cultural, or that it has to do with I don't know, with the history of colonialism and dictatorship, military dictatorships, but I do think there are also legal causes to populism, and this is kind of what I would like to look at as as Eva was also pointing out. Whether I am able to make a connection between the theoretical research and a more comparative study, or a study in social legal aspects, or trying to look at contemporary cases. I'm not sure. I'm a bit hesitant of whether I will be able to do that, but I do certainly want to provide at least some clarification, not only now to this arbitrary power topic, but also to the idea of populism. So I think conceptual clarification is useful also for trying to deal with I guess real cases of populism, and it really does allow, at least it has allowed me to understand better what's going on in my country, which is Mexico. So even with a research that is so theoretical, I have come to understand better the reasons why, or at least the legal reasons why we have the president that we have, for example. So I don't know if I missed something with that.
No, I think you've answered all of the questions. Thank you very much. Thank you, Sonia, for such a fantastic, insightful presentation. I congratulate you again. Thank you, Jocelyn. Thank you, Eva, for your comments, for a great contribution, honestly, to the overall understanding of the topic. And thanks all who attended and posted their comments. Especially Sigmund's comment was, by the way, very useful in terms of preparation for the postdoc project, because the postdoc project usually involves engagement with the non-experts. So maybe you may wish to think about that later on. Having this said, let's meet our next speaker next week. And Michelle Hughes, PhD candidate, School of Law, London School of Economics, will present her project titled Constitutional Design as Enabler of Peace, Colombia and its Constitutional Reform of 1999. Tom Frost is going to be the discussant. So see you all next week. Thank you very much.
Yeah, thank you very much, Dr. Jocelyn, Eva, and Yusuf, and everybody.